there's any emergency, she'll jump on in my stead. Today is going to be a bit of a whistle-stop tour. Care fee planning is quite a vast area that we could discuss, and because everybody's circumstances vary and the assets that they have are also different, it really is kind of a brief overview. But if you have any questions, as Alice has said, please just pop them either in the chat or make a note of them and we'll discuss them at the end. Okay. So a little bit about me. I am a fully qualified solicitor. I am the founder and CEO of Cersei Law, which is a niche law firm that specialises in what we call private client. Private client in legal terms covers everything from wills and probate, estate administration, tax planning, and things like care fee planning. All those kinds of things. It's quite broad brush, so anything that deals with kind of older or later life, taxes or death, the fun stuff, as I say. I'm also a fully accredited member of the Law Society's Wills and Equity Committee, which means when there's exciting pieces of legislation like the assisted dying bill that's currently going through, I get to consult on those matters. I'm also a fully accredited member of both STEP and the Association of Lifetime Lawyers, their extra qualifications in this particular area of law, and do lots of various other bits and bobs. So care fee planning. This care fee planning, it can be quite broad, and the way that people approach it can be very, very different. Now, care fees encompass the expenses that are generally associated with professional care services, and that might sound like a really obvious thing to say, but there are some things that aren't technically what we call care fees, and therefore we're not technically planning for those today. And as our life expectancy continues to lengthen, and with predictions that 1 in 3 people over the age of 65 will develop something like dementia, then care fees are an ever increasing consideration for our growing aging population. There is, though, ways that you can, with effective planning in advance, mitigate some of the costs that may be involved. And really the trick is not to just wait and see what happens and hope for the best. It really is to start getting that planning well in advance to make sure you're well equipped to help meet those care costs, but also maximise the value of your estates, which you inevitably want to leave to your loved ones, rather than being used entirely towards care. Care fee planning allows you to work with professional teams. It's usually a bit of a holistic approach between your lawyer, who'll prepare your legal documents for you, and your financial advisor as well, who can talk to you about different specific financial products, and possibly your accountant too. So it usually takes a bit of a team effort to come up with a robust plan. At the moment, there is actually no cap on the total amount that you may need to pay in care fees. There was some discussion a couple of years ago that there may be a cap of £86,000. I had a little look this afternoon on the internet, and worryingly, all over the internet, there still seems to be this reference to this £86,000 cap that they were talking about introducing, but that was scrapped, unfortunately. So the idea was, with the cap, is that would be the maximum amount you would pay in your lifetime for any care fees, and everything else that you owned would remain yours and you could pass on to your descendants. But there is no such thing, which means your entire estate practically could be eaten away by care fees should you need care for a long period of time. And you'll be paying care fees if your estate is over £23,250. That's the current limit as to when your responsibility for paying those fees starts to taper off and the local authority starts to take responsibility for them. It can mean that because this allowance is so low, it can mean that some individuals are forced to sell their home in order to help them pay for care fees. And this is something that a lot of people want to avoid for all manner of reasons. We'll get into that a little bit more as we move along. Dealing with what amounts to personal care. In terms of care fee funding, we refer to personal care as residential care, nursing care, and kind of needed support with washing, dressing, eating, and taking their medications. That's generally what we're referring to when we're talking about care fees. What it doesn't strictly cover is general things like food and energy bills, general accommodation where it isn't obviously residential or nursing care, their general lifestyle and well-being, and any sort of knickknacks and things that they may need along the way. So the personal care side of things, generally you're still responsible for paying for that, and we're talking about those professional care fees, whether you or the local authority will be responsible for paying for those. So yeah, when applying for care, the local councils, the local authority will conduct a financial means test, and they will look at a whole variety of things to decide to what extent you should be responsible for paying for your own care. Essentially, it's going to look at the things that you own, so your capital assets, and it's also going to look at what sort of income you have as well, and it will take both of those things into consideration when deciding what your liability will be towards your own care fees. This is kind of all governed and overseen by the Care Act 2014. So your financial assessment officer from the council, they will ask you about earnings, any pension income that you may have, what benefits you receive, your savings, the value of your property, those kinds of things. It is to be noted that a lot of people will own assets jointly because they may be married and they might have joint accounts or own property jointly. They will deem it as though you own half of that joint property. That's kind of the standpoint, unless there is really strong evidence to suggest that it's held in some other way. They're not generally going to ask you about the value of your individual possessions, because generally speaking, they don't often hold tremendous value. And they also generally won't talk to you about your life insurance policies, because the thing about a life insurance policy is that it doesn't pay until you pass away. And when you pass away, you no longer need care. So it's not payable to your estate during your lifetime, can't be used towards your care fee funding. A lot of people ask, will your home be included in means testing? And this is not a black and white answer necessarily, I would say. Yes, it can be included in means testing, but there are some limits that I'll get onto in just a minute, where it should be disregarded. Local councils, though, they do have discretion as to whether or not they will include your home. So even if you don't meet some of the requirements for the statutory disregard that we're going to come on to, local councils do have discretion to be able to not include the value of the home in your means testing for care fees. Whether they will or won't is entirely down to what caseworker you may be dealing with and the individual local authority that you might be dealing with at the particular time. I've had some local authorities that have been very, very good, have been very accommodating and quite helpful. There have been others who strike a very hard and fast line. And they won't, unfortunately. So your home will not be included in your means testing if you require care at home, okay, because you need that home to receive the care inside of it, and so it should be disregarded. If your stay in a care facility is only going to be short, for whatever reason, because you're going to recover, you're going to get better, or you're going to come back, so if it's like respite care, then your home should not be included in any means testing for that either, because you need a home to come back to ultimately. And if you do move into a care home permanently, but one of the following individuals remains living at the house that belongs to you, then it should also be disregarded. So if your partner or your spouse or civil partner remains living there, okay, so where we have a couple that come in and they say they're really worried the house will be sold, and the party of the couple who doesn't need care may be forced in a difficult situation, that's not going to happen, okay? While they're in the house, it should be disregarded. It even covers having an estranged or a divorced partner if they're living in the house as a lone parent. When you move into care, the house should be disregarded. If you have a close relative who is living with you and they are over the age of 60, again, the house should be disregarded when it comes to your means testing for your care fee funding. And if you have a child who is under the age of 18 and living with you, again, that property should be disregarded. Now, what I will say is that I have come across some local authorities, I will not name them, but they have persuaded the remaining spouse that's remaining in the house to sign a deferred payment agreement. So even though they should be disregarding the value of the house, they've kind of waived that by getting the spouse who lives in the property to essentially sign to paperwork to say that the care fees can amount against the value of the property that belongs to the partner in care. It's not appropriate. It's quite underhand, if you ask me, but because there's a lot of mystery around what happens in these situations and not everybody knows what their rights are and about the statutory disregard, this has been happening to various people, and they're not knowing that it should be disregarded. So your home will be included in your means tested if you're paying for a care home and you need to move permanently into a residential care home, and none of the above classes of individuals are living in your property. It's really important that if there's a possibility that you are going to need care, and that's going to be a likelihood for 1 in 3 of us, that you prepare financially for your care. Okay, so you need to know about the limits, as I've mentioned, that if you have savings and assets that exceed £23,250, then you are typically expected to pay for your nursing home and care fees in full. If your capital falls between 14,250 and 23,250, then you will likely need to contribute something towards your care costs, but not everything. The local authority will pick up a large portion of the bill. And where your estate is less than that value, then the local authority should essentially be picking up all of the care fee costs that are involved. It is important that when moving into care, you ensure that you have all of the benefits that are available to you. I have some clients who are very principled and don't want to claim certain benefits, but it will be treated as though they were claiming those benefits for the purposes of means testing for care fees. So they're kind of doing themselves out of some funds there. So if you can, please do make sure that you apply to help counter those care costs. One of the main concerns when it comes to losing the sort of family home in care situations is that it's often, certainly in these parts of the world, the largest asset that is in someone's estate. It takes up the bulk of their estate, and they're quite keen to ensure that they protect that so that they can pass it on to their children or grandchildren or other beneficiaries as they may choose. They don't necessarily want to resort to having to sell the family home. There are some things that you can do in order to protect the family home. One of these is care annuities, which I'll go into a little bit more detail in a moment. Another would be appropriate use of trust. And I put the word appropriate in there because not all trust structures are appropriate in these circumstances, and making use of the deferred payment scheme, which again, I'll go into a little bit more detail. A lot of people get bad advice, I would say, about the situation when it comes to their home. I have had to rectify situations where older or vulnerable people have been persuaded, perhaps by unregulated individuals, to place their home into trusts. And they are promised that it will protect it from inheritance tax, they are promised that it will protect it from care fees and all of those other things. And in reality, it doesn't do any of those things, because there are some really strict rules when it comes to gifting and creating trusts, and them you still retaining a benefit in those assets. And so they don't generally have the inheritance tax benefits that they claim. And certainly from a care fee perspective, we will come on to in a minute something called deliberate deprivation, which essentially means that everything can be unwritten and that those assets that were settled or gifted away can be clawed back into the estate for means testing, for care fees purposes. So I would say it's really important that you get an advisor who is appropriately qualified and has experience in dealing with these matters to make sure that you navigate them properly and don't fall into any of the traps. So first way to help protect to get care fees is to potentially speak to your financial advisor about a care annuity. So care annuities can only be taken out if you have a immediate need for care. So if you know that you're going to need that care right away, it is possible to take out a care annuity, and you essentially pay a lump sum and it will guarantee to continue paying your care for the remainder of your life. Now, this is a bit of a gamble because the way that they work out what that lump sum will be is that they essentially have an individual, an actuary, who will come out and they will assess how long they effectively think you will live with your care needs. And based on that, they will come up with a premium. Now, if you don't survive as long as they expect you're going to, then you may have lost money because you've paid more on the annuity than you may have in care fees. However, if you live longer, and I have some clients who've lived much longer than what they predicted, then actually you've effectively saved money because you've only paid the fixed lump sum for the care. And for those of you that happen to have taxable estates, I try to encourage you to think about the care annuity as being sort of 40% off, because if you have a taxable estate and that lump sum was left in your estate and you passed away, you're going to be taxed at it at 40% for inheritance tax. So even though the premiums may seem high, you've got to think about, reframing your perspective when approaching these. The benefit of this is that if there's long or complex kind of care needs, you guarantee that those fees are going to be met for the remainder of that person's life. That can be relief to the person requiring care. It can be relief to the family because they know that what's left after those premiums are paid is essentially what will be the inheritance that will come their way. It means that you may be able to start tax planning with the permission of the court with some of those leftover funds because you have secured that future for the person who requires care. So they are something that should be considered, but because they are a financial product, you do need somebody who's regulated by the Financial Conduct Authority. So that will be a regulated financial advisor to speak to. Okay. Another way is by sort of appropriate trust. And I touched a little bit on this just a moment ago to say that sometimes it's not appropriate. One way in which it may be is we're seeing that when one partner passes away, they may have concerns that if they leave their entire estate to the survivor may go on to need care in the future, and that could then put the entire combined estate of that couple at risk for care fees, of being depleted and not leaving an inheritance for their children. So what we are seeing is that people are planning ahead and in advance, and they may be putting something known as a life interest trust in their will in respect of their share of the property. And what a life interest trust does is it ring fences their share of the property, let's say 50%, because that's nice and easy. It will ring fence their 50% of the property so that their surviving spouse can continue living in the house rent free. They could downsize if they wanted and transfer the trust. If they moved into residential care, they could receive an income from the 50% that represents the trust. It's lovely and flexible, but ultimately, whilst they can receive the benefit or an income from that share, the person who passed away has ring-fenced their 50% to pass to their chosen beneficiaries, i.e. their children or their grandchildren usually, but anybody else who you might want to benefit. And this effectively keeps their half of the estate outside of their spouse's estate, so it won't be included when assessing their means-tested sort of care fee funding. This can be an effective way of doing it, but as I'll go into more detail with a deliberate deprivation, you have to be careful about the motivations for this. These types of trusts are good for a number of reasons and not just care fee planning. It means that when the survivor, if they entered a new relationship or they got married in the future, it means that they couldn't redirect where the first to die's share of the property is going to go. That's nice and protected for the chosen beneficiaries. It can also protect it from potential fraudsters who may try to take advantage of a vulnerable widowed individual for their own financial gain, because again, it sits outside of the survivor's estate. So there are lots of different reasons why these types of trusts might be good. They can be somewhat tax efficient as well, because if the person that you're benefiting in the first instance, the person that you're allowing to remain in the property or receive the income, if they are your lawful spouse or civil partner, then that trust is treated as though everything had passed to that partner spouse exempt on your death, even though you've held it protected in this lovely little trust. So there's lots of different reasons, and appropriate advisor who's familiar with these types of trusts will be able to walk you through all of them. And also there's an administration element that's involved. Trusts need to be registered now with the Trust Registration Service. There's reporting requirements with HMRC as well. So it's not something to be done lightly, and your advisor should walk you through all of this. If anybody is saying to you, I can put your house in trust and I will save you all inheritance tax and I will save you all care fees, then they're lying to you. Essentially, they're not right, and they may not know they're lying to you. They may believe that, but they are not correct. There is also a deferred payment agreement, and I referenced this where local authorities have been inappropriately asking spouses to sign on to them, but where they are appropriate, this can be really helpful. It might be that the family home has some sentimental significance. It might be that one of the children wants to effectively buy out the family home at some stage when their parents passed. And instead, what you can do is you can sign up to a deferred payment agreement where essentially the local authority will, they're not necessarily disregarding the property as such, but they aren't expecting you to sell the property to fund the care fees. The local authority instead will fund them, and then it's basically like an IOU back to that person's estate, so that once they've passed away and the property is either sold or transferred, however it may be, as part of inheritance, then at that point they will be reimbursed for their fees. So this can be a good way of helping sort of retain those family homes within the family, if possible. There are other options as well to consider, and again, this should happen in conjunction with either your financial advisor or your legal advisor. And one would be an equity release. Now, equity release, they do get a lot of bad press, and I can see why they get a lot of bad press, because their charges can be astronomical. In certain circumstances, they may be warranted. So where we have a situation where someone may be asset rich but cash poor, and they want to realise some of those funds to help pay for things like care fees, whether it be a care annuity or just to continue to pay for them, it might be appropriate. Again, that allows you to retain the property in that person's name, but you are releasing some of the funds that are available to it. Again, speak to a financial advisor, because those charges they can rack up. You might want to consider renting out your home. So if you're moving into permanent care and you're no longer going to be living at your home, rather than simply assuming that you have no option but to sell that property to fund care, you may be able to rent it out, get a good return that can help you combat some of those care fees in conjunction with any pension payments and any other benefits, etc., that you may have to pay those care fees. You can also give your home away, and this is in there, and it depends on how soon you're kind of planning in advance with this, because again, there could be snags with deliberate deprivation, which is next. If you were doing it far enough in advance and there are other considerations, for example, inheritance tax planning, if that's your main motivation, because you get principal private residence relief on your own home, so you're not having to worry about capital gains tax or anything like that if you sell, transfer it, gift it away. It can be a good position to tax plan with an inheritance tax plan with your property, because you can either sell it or gift it away to your beneficiaries and then move into another property, and that new property will then gain the principal private residence relief as well from there on out. So you might be downsizing and gifting, whatever it may be, but you have to be careful, because if there is a likelihood that you may need care, strong likelihood, or you're anticipating that being in the near future, then you may get caught out by the rules of deliberate deprivation. And what we mean by deliberate deprivation is this is kind of a mechanism that the local authority can use, whereby they can claw back assets that you may have gifted away to people, that you may have settled into a trust or done various other things with, and they can claw that back into your estate for means testing for your care home fees, and who's responsible for them. And they can do this with the assistance of the court, and they're getting very, very good at doing it. So any planning you do has to be really robust, and they will want to claw those funds back in, because the more funds that you have back in the estate, the more funds are available to pay for the care fees, and the less that the local authority have to pay. And this can cover any kind of asset. So it's not just in relation to your property, but if you're gifting away investments and saving and other forms of income as well, they could use the deliberate deprivation rules to try and claw that back into your estate. This can be lengthy, it can be really stressful, it can be really expensive, and certainly if you have gifted the property away to other beneficiaries, what's to say that they still have those assets to essentially reimburse the estate when this happens. Sometimes we're talking several years could have elapsed between the date of the transfer or gift, and so there can be a lot of unwinding to do there. So it's important not to fall foul of these rules. And when we're considering whether there has been a deliberate deprivation, the local authority and the courts are going to look at three key factors, and this is your timing, your motivation, and your foreseeability. Okay, so timing. Okay, they are more likely to pursue a deliberate deprivation claim if you're gifting assets when you're 89 years old than perhaps when you're 59 years old. Okay, because there's an implication that the older you get, the more likely it is that you may need care. The motivation behind it. So have you got other reasons? So for example, are you concerned about your surviving spouse remarrying and leaving assets to the new family? You know, is that why you've chosen to have a trust? Are you concerned about a surviving spouse potentially being really vulnerable to fraudsters? Is that why you've opted for this type of planning? It could be all manner of things. It can be very, very circumstantial. So your advisors should be getting a really good feel of you, your family circumstances, what's going on, those motivations behind this. If you're saying the sole motivation is to avoid care fees, well, it's quite likely the local authority will be successful in a deliberate deprivation claim. And lastly, the foreseeability. If you are in perfect health and have no concerns about needing care in the future, then, you know, this is the foreseeability element. It could be argued it's not deliberate deprivation, because it was very, very, very unlikely that you were going to need that care. However, if you've started getting more frail or more ill, you've had a certain diagnosis, and suddenly it's very clear that you will need care at some point, even if you don't need it immediately, well, then you may fall foul of this third element here, and the local authority could very well be successful in any deliberate deprivation claim that they bring against you. So the key is to get good estate planning advice here, because there are a lot of moving factors. We have things about, yes, the motivations and your family circumstances. There's elements about what assets that you may have. Your portfolio may be very different. It's about the interaction with different taxes, as well as this interaction with potential care fees. It's a fine balancing act. And, you know, genuine estate planning to reduce the value of your estate for inheritance tax purposes and to protect certain assets for beneficiaries is permissible, providing that the overriding objective is not to deprive local authorities of potential fees. Okay, so kind of stressed this already, but with that professional advice, you can get tailored strategies. So everything we've just spoken about so far has been very, very high level, because everybody's individual circumstances will vary, their assets will vary, and therefore the strategy and the advice that they need to receive should be very varied as well. I would recommend that when looking for a lawyer, you look for people who are either accredited with the Association of Lifetime lifetime lawyers or with the Society of Trust and Estate Practitioners. They are additional qualifications in this particular area of law, and they're kind of the gold standard for this type of work. So you can expect a good standard of care from your legal advisor if they're accredited with them. You also should ensure that you've got a decent financial advisor, as I've mentioned previously, because the two roles, when care fee planning, are going to interact very, very closely. And of course, we can't think about care fee planning without also considering the use of powers of attorney. Now, powers of attorney are extremely powerful documents. They are documents that you make whilst you still have full mental capacity and can make decisions for yourself. You put them in place now in the hope that you never need them. But if you do need them in the future, then they're already in place. And this is because you cannot make powers of attorney once you lose mental capacity. So if you have an accident or you have a condition of the mind that has deteriorated to the point where you cannot comprehend and make your own decisions, it's too late to make powers of attorney at that point. So you have to put them in place in advance, and there are two types. There is one for your health and welfare, and there is one for your property and finances. And when we're looking at care and we're looking at care fees, they are both as equally as important as each other. You need the health and welfare document to arrange the type of care that's going to be received, but you need the property and finance document in order to pay for that type of care. With the documents, you can appoint people that you trust, and you absolutely must trust your attorneys because they effectively will be stepping into your shoes, will have the same rights and responsibilities as you have. Incredibly powerful documents. So they shouldn't be anybody who has a criminal record, who are financially financially irresponsible, shall we say. They have to be over the age of 18, and they shouldn't have been made bankrupt at any point in their life. Okay. You don't have to appoint your family members. You can appoint friends or professionals if you feel that your family aren't quite up to the task or you're a bit concerned about how they'll handle it. But they are incredibly important documents. In particular, with the health and welfare LPA, when we're thinking about care, this document can only ever be used when the person who creates it, the donor, cannot make decisions themselves. So while they're able to, they will always make decisions about their own care, their own treatment. But if they're incapacitated, then your attorneys can make decisions about what care you receive, where you receive that care, things like who can and can't visit you, which can help in safeguarding you if you're particularly vulnerable against any fraudsters. It can also give them the power to deal with any treatments that you may receive, including any life-sustaining treatment, which is any treatment which will not cure you, but it will prolong your life. So a classic example of that might be a life support machine. Incredibly powerful documents, really important. I have had situations where a health and welfare power of attorney has not been in place, and we have an elderly couple, and for example, the wife may develop a UTI or have a slip or a fall and wind up in hospital. The social services there will then do an assessment. They deem that her care needs are such that the ailing husband is no longer able to provide that care, and so they then place her in a care facility. And because there are no legal documents in place, regardless of him being the next of kin, which has no legal standing, they can do that. They can seek an order from the court to do that and place her there. And in one circumstance, I've had a client where this was a care facility 2 towns over, and he had to take 2 different buses every day to go and visit her. Now, if you have a health and welfare power of attorney in place, you can effectively intervene there, and you can withdraw consent for that individual to be placed in that care facility by social services, and social services are not able to override that, and the local authority can't override your power under a health and welfare LPA. Okay, so very, very powerful documents. If you don't have them, please make sure that you do get them in place. I've got my contact details there if anybody would like to jot them down. As I said, very complex, detailed area of the law and finances, so whistle-stop tour. But if you have any questions, please do let me know.
Thank you, Jade. That was really interesting. Yeah, it's very helpful. Thank you. Has anyone got any questions for Jade? If you do, then just pop them in the chat or unmute. So, actually, Jade, I wanted to ask something. If the council pay for all or some of your care fees, do they get to choose where you go, which care home you go to?
I mean, as a general courtesy, they try to engage with the family as to somewhere that is suitable. That has to be said. Obviously, the story I gave is a bit of a horror story as to what can happen. But yes, generally, they will have to have some involvement in the approval of the care home because they are funding the bill and they will want to ensure that the right level of care is an appropriate facility and that the fees are effectively within what they want to pay.
Thank you. Are there any other questions?
Is there anyone from a local authority here?
Oh, sorry. Let's look at the chat. Can families top up fees?
Yes, you can top up fees, but you are not obligated to do so. Okay, so the person who requires care, their finances are very separate from your own. And there is no legal obligation for you to top up those fees. But if as a family you make that decision that you have the means to be able to top them up and the desire to want to top them up, it might be because you actually want a higher standard of care, a better care facility perhaps for your loved one, then absolutely you can top them up. And from your own perspective, if you are doing that and you are doing it on a regular basis, there can be an implication that you might be making gifts to the person who needs care for your own tax purposes, but there is an exemption for that when it comes to inheritance tax, and that is known as normal expenditure out of income. So the revenue says that as long as those gifts or those payments, those top-ups, are not impacting your normal standard of living, so you can still, go about your day-to-day life as you normally would, then they won't have an impact on your estate for inheritance tax purposes. They will be treated as normal expenditure out of income and disregarded when it comes to your own inheritance tax liability.
I think we had another. Let's just check the chat. No, any more in the chat? No. Okay. Is that all the questions for Jade? Yeah. Lovely. Thank you so much.
If that's all right. If you've got any specific circumstances, as I said, it's really hard sometimes to, kind of give meaningful advice on these sessions because it has to be quite broad. But if you have specific circumstances you're not sure about and you want to just email me those circumstances so I could perhaps advise you more specifically, please do. I don't mind doing that. Either myself or Jess will come back to you and just sort of nudge you in the right direction if that's what you need. And we do offer free initial consultations anyway. So if you wanted to come in and have a chat and just know the lay of the land for your specific circumstances, then please do take us up on that.
Thank you, Jade. I've put up this screen here because I just wanted to mention that we also have our Make a Will month this May. So we've got an offer of discounted wills where local solicitors, including Jade, have given up their time to write discounted wills in return for a donation to the hospice. So there's more details on our website about that. So you can get a simple will written or updated with one of the local solicitors for a suggested donation to the hospice. And we also have some drop-in sessions at our hospice cafe. The dates and times are on the website as well. And we have one session at the Reading Superstore. No need to book and they're free, so just come along. Because we mentioned this because 1 in 5 of our inpatient beds are funded through gifts and wills. So it's a vital part of ensuring that we're here for future generations. If you are thinking of leaving a gift to the charity in your will, then please do consider the hospice, and we'll be very happy to answer any questions that you might have as well. But yeah, I've got a poll, and we'd be interested to know your thoughts as to what would be your preferred topic for future webinars as well. So if you're happy to just fill that out, that would be great. Thank you. Hopefully you can see it. Can you see that? Yeah. No. Back to question.
There's a poll it's just a tick and a cross box.
Oh,
but there's
okay,
no,
that's no good. If it's not working, then I'll send out the question. Oh, let's have a look. This is the first time I've done a Teams poll, so apologies. But what I'll do is I'll send the question out afterwards, along with the recording as well. So we'll do that. But yeah, thank you so much, Jade, and thank you for joining us today. And yeah, enjoy the rest of your day.
Thank you. Yeah, and the same to you guys over there. And
Thank
yeah,
you.
Thank you very much.
you're very welcome.
Thank you, Jade. Thank you.
Bye-bye.
Bye-bye.
Thank you. Bye.
I'll just. Did you want to stay on for a minute, Alice?
Yeah, I'll stop recording as well.